Morning, everyone. I'm Judge Corey Amanda Coffin, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, so I encourage you to speak with your attorney before speaking on the record today, because everything that we say is being recorded and can be used against you at a later date. If you are represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me to address your case from here. If your attorney is not present in the courtroom when I call your name, you can let me know that and we will try to facilitate you through that process. However, I ask you not to tell me that you have private counsel unless you or your family have retained counsel for this specific arrest. You also need to know that this morning I have in the courtroom with me attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here to facilitate the morning session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here on misdemeanor or municipal ordinance matters, but understand that that determines what happens with that is reliable on what is going on with you personally and your case. For felonies and violations of probation matters where the judge has already set a no bond hold, know that that cannot be resolved here at first appearance. After today, your case will be assigned to a specific division judge, and going forward, all subsequent motions and any trial will be heard by your division judge. Before we get started with our regular docket today, we do have a couple of cases that the jail has requested to be called out of turn. Mr. Reedy, I understand we only have 2 of those, is that correct?
Yes, Your Honor, we have the Millers.
All right, I will start off with those cases and then I'll go to those who have people signed in this morning. First will be Roy Miller. He is on page 6.
Good morning, Judge.
Good morning, Mr. Romero. Good morning, Mr. Miller.
Good morning.
Mr. Miller, you're before the court this morning on one count of trespassing of an occupied structure or conveyance. I find probable cause, and I'll hear from the parties.
Judge, at this time, nothing to add on behalf of Mr. Miller.
Okay. State? All right, the standard bond will remain in place. There will also be a no return order. So, Mr. Miller, that means that you are not to return to this specific location until further order of the court. Do you understand that?
Yes, ma'am.
Thank you. Next will be Quentin Miller. He's on page 10.
One moment, Judge.
Thank you.
Mr. Miller's here, Judge.
Good morning, Mr. Miller.
Good morning.
You're before the court this morning on one count of possession of heroin. I find probable cause, and I'll hear from the parties.
Judge, nothing to add at this time.
Okay. State?
Nothing from the state.
All right. In light of that, the standard bond will remain in place. Thank you. Next will be Glenn Holt on page 13. His private counsel is present in the courtroom.
Good morning, Your Honor. Eric Rudenberg on his behalf.
Good morning, Mr. Rudenberg. Thank you.
Your private attorney is here, Mr. Rudenberg.
Good morning, Mr. Holt. Your private attorney, Mr. Rudenberg, is here in the courtroom with me. For the record, you're before the court this morning on one count of burglary with assault or battery. I find probable cause, and I will hear from the parties.
Your Honor, I've spoken with counsel this morning, and we have a bond agreement if it's acceptable to the court. Just want to note for the record, Your Honor, I've also had contact with the alleged victim, and he has no objection to this court issuing a bond and ordering no victim contact. And the agreement we've reached would be a $20,000 bond and an order of no victim contact.
That's correct, Your Honor, and that's agreeable to Mr. Holt.
light of that, bond will be set at $20,000. There will also be an order of no victim contact. Mr. Holt, so that you understand, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir? You can push the button in the middle of the podium there so I can hear you.
Yes, ma'am.
All right, thank you very much. Thank you, Mr. Rudenberg.
Thank you, Your Honor.
Next will be Sean Bell on page 18. His private counsel is here in the courtroom.
Judge Rachel Cole standing in for David Howard on behalf of Mr. Bell.
Good morning, Ms. Cole. Yes.
He's not here yet. The deputies are on the way to get him.
Okay, just let me know when he's in there, okay?
I will,
All
Judge.
right, so Ms. Cole, I'll place him on a brief recall.
Thank you.
Shay, you ready to do yours? All right. I don't have him signed in on anything. Okay. All right. All right. Okay, good morning, Mr. Shades. All right. Okay, so we're gonna do, if we have these individuals present, then we'll start off with the municipal ordinance matters. On page 1, I have Miss Aminia Howard.
6 or 10.
It says page 1 on my.
Correct, yes.
Yes. Okay. Okay.
It's a time-served offer, Judge.
Does anyone at Maine have Miss Aminia Howard?
She's in Paul Ryan, Judge?
Okay, well, let's try Paul Ryan.
Okay.
All right.
Who's gonna look for you, Honor?
This is Miss Aminia Howard.
She's in court, Your Honor.
Okay, all right. So then we'll have a recess. Okay. She's in court. All right, on page 6, Inpeng Thepithak.
Same way I would have pronounced it.
I'm sorry,
Same way I would have pronounced it.
I try. Oh, thank you. Okay, Mr. Thepithak, good morning.
Go ahead.
Your attorney is here present in the courtroom with me, and for the record, you're before the court this morning on a misdemeanor capias. This is a municipal ordinance violation. It appears to be an alcoholic beverage violation. I find probable cause. And Mr. Shea, what are we doing with this case today?
It's a time-served offer, Judge.
Okay, so Mr. Thepithak, if you would like to resolve the case today, the city's offer to you is an adjudication time served.
Yes, ma'am.
Would you like to accept that offer?
Yes, ma'am.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. Do you understand everything that we discussed here today?
I think so.
Okay. Is there any questions that you have for your attorney?
No, ma'am.
Okay. All right. Is anyone forcing you to resolve your case?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Okay. All right. Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, not really, no.
Okay.
No.
Okay. All right. Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Okay. And do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
All right. And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
Okay, I accept your plea and find that it is freely and voluntarily given. So, Mr. Thepethak, once again, your sentence will be an adjudication, time served. Good luck to you.
Thank you, ma'am.
Thank you. Okay, also on page 6, I have Anand Prasad. Good morning, Mr. Prasad.
Good morning.
Mr. Prasad, your attorney is present here in the courtroom with me, and for the record, you are before the court this morning on 2 misdemeanor capiases. These are each for municipal ordinance violations. Count 1 is for trespassing, and 2 is for an alcoholic beverage violation. I find probable cause, and Mr. Shea, what are we doing with Mr. Prasad's case?
Judge, it's just both one case and it is a time served offer for $4.
It's an adjudication time served for both?
Yes, ma'am.
Okay, so Mr. Prasad, if you would like to resolve the case today, the city's offer to you is an adjudication time served.
Will you say that again, please?
The city's offer to you, if you want to resolve the case today, is an adjudication time served.
What does that mean? Because of the time served, the case will be dropped?
So you'll be getting out today. As long as
Okay,
this is
well-
the only thing holding you, you'll be getting out today.
Okay, well then, let's do that, please.
Okay, all right, so Mr. Prasad, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, I do.
Thank you, you can put your hand down. And do you understand everything that we've discussed so far today?
Yes, I have.
Okay, is anyone forcing you to resolve your case?
No one.
Are you under the influence of drugs or alcohol?
No, I'm not.
Do you need any more time to speak with your attorney?
You need
I
more-
will maybe later on, I don't know.
Well, do you
If you
have
want.
any questions for him about this case?
Not right now.
Okay.
Now would be the time to ask them. If you have any questions,
Pardon?
now would be the time to ask them. Do you have any questions of me?
No, I think you said it's been resolved. I go home today and
Okay,
I
so,
don't have any further questions, thank you.
okay, all right. So, Mr. Prasad, do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes,
Okay, and have you ever been treated for mental or emotional illness?
yes.
Okay, is there anything about that illness today that impacts your ability to accept this plea?
No,
Okay. And do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
I understand.
Okay, and what plea do you wish to enter, sir? Guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. And Mr. Prasad, once again, your sentence will be an adjudication time served. Good luck to you, sir.
Thank you, Your Honor.
You're very welcome. Okay, and then, Mr. Shea, I have McCorkle on your list, but I don't have paperwork.
I believe this was welcome to domestic violence courts.
Okay, all right, so is that all I have for you
I
today?
believe that's it, thank you.
Okay, thank you very much.
Excuse me, Your Honor.
Yes, Deputy.
Sean Bell is in the courtroom.
Okay, perfect, thank you. All right, so Ms. Cool, come on up. Good morning.
Rachel Poole standing in for David Howard on behalf of Mr. Bell.
Thank you, Ms. Cool. All right, good morning, Mr. Bell.
Good morning.
Mr. Bell, your attorney is present here with me in the courtroom, and for the record, this morning you're before the court on one count for possession of a weapon or ammunition by a convicted felon. I find probable cause, and I will hear from the parties.
Your Honor, I'm not contesting probable cause. However, according to the probable cause affidavit, the defendant was under the impression his civil rights had been restored, thus allowing him to possess a firearm. He does have priors. They are old priors. He's not a flight risk. He did voluntarily surrender himself to the police department. I would request a $1,000 bond.
Fine with that, Judge.
Okay. All right, then, in light of that, bond will be set at $1,000.
Thank you. Mr. Bell, I'll let Mr. Howard know, and you can have your family post the bond, okay?
Thank you.
All right, thank you, Mr. Bell.
Thank you,
Thank you,
Judge.
Ms. Cole.
Our Creole interpreter is present, Your Honor.
Okay, so let's go to, we have two cases. All right, good morning. Will you please raise your right hand? Do you swear or affirm to interpret from Creole to English and English to Creole to the best of your ability? Thank you, Ms. Sinaj. And the first one up is going to be Wilzer Francois on page 8.
Francois.
Approaching, Judge.
Thank you. Good morning, Mr. Francois.
Bonjour, Monsieur François.
Mr. Francois, you are before the court this morning on an ad charge.
Monsieur François, ou devant le tribunal là, parce que vous ajoutez une accusation.
This is for an immigration hold.
Ça, c'est pour quelqu'un bon dans l'immigration.
I find probable cause.
Je joue une cause probable.
And Mr. Francois, this has a no bond hold,
Monsieur François, ça a gagné, pas de caution.
which means you will have to go before an immigration judge to address this matter.
Et qui veut dire qu'il faut aller devant un juge d'immigration avant.
Good luck to you, sir.
Bonne chance, monsieur.
Next will be Basil Pierre Lewis on page 11.
He's approaching, Judge.
Thank you. Good morning, Mr. Pierre Lewis.
Bonjour, Monsieur Pierre-Louis.
You are before the court this morning.
Ou dans le tribunal le matin.
Count 1 is resisting an officer
Accusation 1, ou résister au officier police
or obstructing with violence.
avec violence.
Count 2 is resisting an officer
Accusation 2, ou résister au police officier
or obstructing without violence.
sans violence.
Count 3 is for a pedestrian failing to walk in a crosswalk.
Accusation 3, c'est que ou pas de marcher côté où tu dois pour te marcher.
That charge is not for magistrate.
Accusation ça, c'est pas pour magistrat.
I find probable cause,
Je une cause probable,
and I'll hear from the parties.
m'a coûté participant yo.
Mr. Romero wants to go first. I don't know what he's requesting.
Judge, my understanding
Juge nan sa ke m kompran.
This is Mr. Pierre's first time being arrested in his life.
C'est première fois Monsieur Pierre yo arrêté nan ville.
He's a registered voter in our community.
Li vote nan communauté a.
He does speak English, but he wanted to make sure he understood everything. That's why we asked for a request for a Creole interpreter.
Li pale anglais, mais il te vle comprendre tout ça qui a passé, c'est ça qui fait le paiement de un interprète. Phil Beach avec madame ni avec ses petites li.
He's the primary financial provider of his family.
Et c'est lui qui occupe tout le monde.
He works at Broward North Hospital in the transportation department.
La travaille dans transportation dans l'hôpital Broward.
Judge, Mr. Pierre, since it's the first time, he's quite confused. He's a little bit emotional.
Et comme c'est
But
première fois ça arrive, li émotionnel.
I have no doubt Mr. Pierre is going to be appearing for future court dates.
M'pa gen aucun doute que monsieur Pierre a vini dans tribunal prochaine fois.
Judge, considering he has no priors, he has very strong ties to the community, I'm going to be requesting the court consider releasing him straight ROR.
Considérant que li pa ko jam gen crime déjà dans ville et li habite dans communauté a, m'a demandé pour la gueule sous propre engagement.
State.
The only thing I want to know, Mr. Romero, could you inquire of him where in Deerfield he resides, what his address
Est-ce qu'on
is?
commande adresse li?
It would be 4331 First Place,
I have,
Northwest.
I got it. I have no objection, Your Honor.
Pas gen objection, juge.
All right, then, Mr. Pierre Lewis, I will ROR you.
Monsieur Pierre-Louis, m'a pas la go sous propre engagement.
That means you will be released today.
Qui veut dire y a la go tout dans prison jodi a.
Please know that even though you are being released today,
Konnen menm si yo lage ojodi a,
that doesn't necessarily mean it's the end of the case.
sa pa vle di ke ka fini.
So it will be your responsibility
Alors, se responsabilite yo
to follow up with your attorneys in the clerk's office
pou ka konnen sa ka pase avek avoka ou,
to monitor any future court dates that you have to be present
pou
for.
ka siveye sou nepot lot dat ko genyen pou retounen nan tribunal.
Do you understand that, sir?
Esko kompren, monsieur?
Yes.
Yes.
All right. Thank you.
Merci.
Okay. Is there anyone else at Maine that needs a Creole interpreter?
Eske gen lot moun ki bezwen interpret kreol?
Not here at Maine, Judge.
Anyone at any of the other facilities?
And not that I've been advised, Your Honor.
Okay. All right. Thank you, Ms. Hanash. Okay. I'm going to start going through our regular stack now. Next up will be Robin Simmons.
Ryan, Judge.
Thank you.
Before I,
Thank you. Good morning, Ms. Simmons.
Good morning, Your Honor.
Ms. Simmons, I'm sorry. All right. Ms. Simmons, for the record, I have you here this morning on an ad charge for a traffic capias. This was for a pedestrian obstructing traffic. Confinement has advised me that the capias was issued while Ms. Simmons was in custody. Is that correct?
Your Honor, I'm sure if Ms. Cooper says it is, I'm sure it is. If Ms. Simons wants to resolve the case, the offer on this would be a withholding court cost. I was advised by Mr. Shade that this case was resolved by Judge Lerner, and they're trying to get her out to get some help. This way she doesn't have to worry about coming back to a future court date. It's up to her, though.
Was this case already resolved by?
This case wasn't, her other cases were.
Okay, all right. So, Ms. Simmons, if you would like to resolve this case today, then the state's offer would be a withhold of adjudication plus court costs.
What does that mean?
Well,
It means you'd have no conviction on your record. You'd have to pay the court costs for the traffic citation, and you'd have time to pay that.
I'm homeless.
Ms. Simmons,
Yes, sir.
I would give you plenty of time to pay those court costs.
Would I be able to be released today?
Yes, ma'am.
Then that would be fine. That I would agree to that, yes.
Okay, all right. And I'm going to, in this case, I'm going to give Ms. Simmons a year to pay her court costs for the record. All right, so Ms. Simmons, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. Do you understand everything we've discussed so far today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Okay. Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking this plea?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Okay. Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, Your Honor.
And Ms. Simmons, what plea do you wish to enter? Guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. So once again, your sentence will be a withhold of adjudication plus court costs, and you'll have up to a year to pay those court costs. Good luck to
Thank you,
you.
Your Honor. Thank you, Your Honor.
Lauren Thornton. Good morning, Ms. Thornton.
Good morning.
Ms. Thornton, you are before the court this morning on counts 1, 2, and 3, DUI with damage to property or person of another. Count 4, DUI, alcohol or drugs, first offense. I find probable cause, and I'll hear from the parties.
Judge, in speaking to Ms. Thornton, I advise her as far as her monetary bond is $3,500. Unfortunately, right now, she's not in a financial position to post that monetary bond. Now, she's 54 years old, been living in our community since 1999. She is a registered voter. At this time, she's in the process of applying for disability. Now, this isn't her first contact with the criminal justice system, but it's been a while, I believe, in her early 20s. She resides here locally in Hollywood. She's been residing in the same place for 15 years. She lives there with her boyfriend. Her boyfriend is the person that basically pays all the bills. He's not going to be able to post her monetary bond, so we're going to be asking the court to consider releasing her on pretrial. And considering as far as the DUI and the other offenses charged, we wouldn't have an objection if the court also wanted to impose as far as no alcohol or intoxicant and subject Ms. Thorne random testing. But we're asking for her to be released on pretrial release, Judge.
Thank you. State.
Your Honor, the state would be strongly opposed to outright pretrial. By my count, this will be Ms. Thornton's 5th DUI. She had 4 prior DUIs in the state of Georgia. And in this case, she not only caused the crash, but injured one of the people involved in the crash. Your Honor, this should be properly charged as a felony DUI. I'm going to be seeking a $10,000 bond on count 4, pretrial release with a TAD monitor, no alcohol or intoxicants, random testing, and no driving.
Judge, I believe in speaking Ms. Thornton. She advised me as far as the priors that the state was referring to. They were, when she was in her 20s, Judge, she's 54 years old. Granted, I don't mean to undermine the situation, but she's not in a position to post any sort of monetary bond. We don't have an objection as far as the state special request, as far as having her placed on a TAD monitor. But financially, she's not going to be able to afford to post bond. She will be coming to court. I don't think she's a flight risk, Judge. She just can't afford to post a monetary bond.
There's just a certain point when you pick up so many DUIs where really the date of them or how old you are when you committed them really doesn't become that relevant when considering the danger someone poses to the other drivers in the community.
Judge, I understand where the state is coming from. However, I don't entirely agree with the state's opinion.
Well, I wouldn't expect you to,
mean,
Mr. Romero.
I mean, it's just in your criminal score sheet, Judge. If you've been clean for 10 years, they're not going to take that into account. So,
Okay, I understand. Let me ask my questions now. What years are the priors?
95 DUI DWLS. 1993 DUI. 1992 DUI. 1985 DUI. Another DUI 91. Your Honor, I would agree. If she was here on some other offense, I would agree. But the fact is, she's here for the same offense,
Have you said?
from what I can tell you.
Okay. For the pretrial conditions that you requested a tab monitor, random testing, and no driving?
Yes.
All right. It's time. I'm going to take a chance on Ms. Thornton and release her to pretrial supervision. She will be placed on a tab monitor. She will be subjected to random testing. That means no alcohol, no intoxicants, and I'm going to order no driving until further order of the court. Now, the next question I want to ask pretrial is, I know with the random testing, the standard is about twice a month. Right? No bond necessary. Correct. Ms. Thornton, do you understand all of those release conditions that I noted?
Yes, ma'am, I do.
All right, thank you. Next will be Nazari McKinney.
I believe North Broward, Judge?
Thank you.
North Broward?
Thank you very much. Good morning, Ms. McKinney.
Morning.
Ms. McKinney, you're before the court this morning on one count of battery on an officer, firefighter, EMT. I find probable cause. I'll hear from the parties.
Judge, I'm going to ask for pretrial release for Miss McKinney. She hasn't been here very long. She's only been here a month and a half, but she does have a boyfriend here that she lives with. And she does have some medical issues that concern me, that she probably would be better treated outside of the jail than inside the jail. So I'm going to ask the court to consider pretrial release for her. She indicated to me that her boyfriend is a disabled veteran, so he's getting subsidies from the government, so he doesn't have a lot of money to post a financial bond, and neither does she.
Well, first of all, I would note she was being treated outside of the jail, but she decided to poke the doctor in the eye in the hospital, and then she got arrested. She's only been here a month and a half, but this is already her second violence-related arrest. She was arrested in early December for threatening to strike a cashier at a business and is out on a $100 bond. Considering it's her second arrest in just a month and a half, really no strong ties to the community. Looks like if she moved here from New York. I'd be requesting a $1,500 bond.
Judge, there's no way Miss McKinney is going to be able to post that kind of a monetary bond.
Bond is going to be set at $1,000. There's also going to be an order of no victim contact. Ms. McKinney, I don't know if you know this individual or not, but no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes.
Thank you. Catherine Miller. Thank you. Good morning, Ms. Miller. You're before the court this morning on count 1, failure to stop or remain in an accident involving non-serious injury. Count 2, leaving the scene of a crash involving damage to property. Count 3 is for careless driving. That is not for magistrate. I find probable cause, and I'll hear from the parties.
Mr. Romero, curious to hear what he said.
I just wanted to see what the state was recommending, Judge.
Well, I have different thoughts, so if you want to go first, it might be to your client's advantage.
Judge, in speaking Ms. Miller, she's been residing in our community almost her whole entire life. She is working. She lives locally here in Coral Springs. She is a widow. She has a 10-year-old son, Judge. She volunteers in our community. She has been basically volunteering in a children's trust group which deals with bereavement issues. She's a registered voter. I have no doubt she'll be appearing for her future court dates, Judge.
What's your recommendation, Mr. Romero?
$3,000 on count 1, $1,000 on count 2, Judge.
Your Honor, and I don't think you can really say that there's no doubt considering the nature of the allegations for future appearance in court. I also have concerns based on the allegations from one of the witnesses that they smelled alcohol on her person. The officer notes a dish of alcohol. She returned 3 hours later to the scene. And I do note there was a previous DUI arrest that was dropped in Palm Beach County, I believe in 2014. I would be okay with a lesser bond than what Mr. Romero recommended, but with pretrial and random testing, no alcohol or intoxicants. With the pretrial supervision, I'd be okay with a $1,500 bond.
Mr. Romero, is there anything you want to add?
Judge and Ms. Miller, I mean, she's working, she works full-time. She's the single mother. I'm just asking for a straight monetary bond, Judge.
Then wouldn't paying less money on bond be more helpful to her?
I think based on the circumstances, giving Ms. Miller the opportunity to be placed on pretrial is probably going to serve her better based on the situation. So I'm going to place a $1,500 bond on count 1. If she posts her bond, she'll be placed on pretrial supervision and subjected to random testing. That means no alcohol, no intoxicants. Ms. Miller, do you understand that?
Yes, ma'am.
Thank you. Black?
She's approaching, Judge.
Thank you. Good morning, Ms. Black.
Good morning.
You are before the court this morning on 2 counts. Counts 1 and 2 are each for child neglect without great bodily harm. I find probable cause, and I'll hear from the parties.
Your Honor, she has a couple petty thefts in her past. Considering the nature of the allegations, the state would be requesting a $1,500 bond on each count, and, one moment, I'm sorry, and no victim contact in an abundance of caution.
Judge, first, I just wanted to know, when's the alleged date of incident?
Your Honor, I can tell you, I pulled the information, I can tell you which charge of the information.
Thank you.
It's between October 24th, 2018 and January 3rd, 2019 on one of the victims, and between July 1st, 2018 and January 3rd, 2019 for the other alleged victim.
Judge, I'm going to be asking for pretrial, and I know the nature of the allegations are pretty seriously, but I think, in speaking with Ms. Black, I believe my request for pretrial is reasonable. First, financially, she can't afford to post a bond. Second, my understanding, Judge, is these incidents, she already went through a dependency court. My understanding, Judge, is she was given a case plan. Initially, I believe the child was separated from Ms. Black and was placed with the paternal great-grandmother. Ms. Black had to complete a parenting course, which she did. She had to complete an anger management course, which she did. She had to complete an individual therapy course, which she did. My understanding is that because Ms. Black successfully completed her case plan, basically she was reunified. Judge, she's 28, been here her whole life. She's working. She works at Broward General in the front desk department, where she's been there for 2 years, making about $12.50 an hour. She's going off to school. She goes to Florida Barber Academy. She goes Monday through Friday from 6 to 10 p.m. The only person that could maybe help post a monetary bond would be her mother, but my understanding is she's in the maintenance department, Cleats Hotel, so financially it's going to be a stretch. So that is why I'm requesting the court consider releasing Ms. Black on pretrial release.
When was that case plan completed?
Judge, I'm a little confused. She advised me 2017. So now I'm confused, Judge.
That makes two of us.
Well, what that could very well mean is that this isn't the first time that child services has had to get involved.
Where are the, who has custody of the minor children at this time? There's 2 children.
They're with Ms. Black.
Your Honor, this is why, and that's why I said in an abundance of caution, because frankly, I think evidence confirming this, a little stronger evidence confirming this is really needed in an abundance of caution.
All right. I'm not sure what's going on with the inconsistent case plan story, but if it was completed in 2017, that obviously predates the issues that are happening in this case. So at this time, I'm going to set $1,000 bond on each count, and I will order no victim contact until further order of the court, which means that the minor children will have to be placed with someone else for the time being.
Judge, if could it, can that order be subject to modification upon an entry by a dependency judge?
Your Honor, the only thing I would ask is that it be modifiable by the circuit court criminal judge assigned to this case. There's different issues between a civil matter and a criminal matter.
Modifiable by the division judge that gets assigned to this case. Okay? Next will be Helen Chirino.
She's approaching, Judge.
Thank you. Good morning, Ms. Chirino. Ms. Chirino, you're before the court this morning on count 1, obtaining a controlled substance by fraud. Count 2, fraud or attempting to use identification of another person without consent. I find probable cause. The date of incident on this.
After she was placed on
Judge, I can't hear you.
I'm sorry, pretrial is standing up. They're asking me for the date of incident, which is January 21st.
The defendant was placed on pretrial supervision on the 31st of December in case number 19-15132-CF10A. 2 counts of obtaining a controlled substance by fraud and 2 counts of fraud attempting to use ID of another. Based on the court's finding of probable cause today, we're going to act that her pretrial status be revoked at this time. It is in essence the same charge as she was placed on pretrial for 22 days.
Based on that information and request, I'm going to grant the request and revoke her pretrial. And once again, that is in case number 19-015132-CF10A. Based on that, I'll hear from the parties as to bond in the case that was originally on pretrial.
Judge, if I didn't hear everything, but from what I can speculate, I believe pretrial informed she was out on pretrial, and they're recommending her be held no bond. Obviously, that's a recommendation, Judge. My understanding, Judge, and I can be wrong, my understanding is Ms. Chirino was out on standard pretrial. What I would ask the court to do, rather than holding her no bond, which is the most severe sanction the court can impose, I'd ask the court to consider placing her on level 2, which would be a heightened form of supervision on Ms. Chirino's behalf.
Based based on the circumstances in this case and the fact that these are almost exactly the same charges that are being brought against her, I'm not going to grant that request at this time.
Your Honor, I'm going to be requesting no bond so that I think this matter needs to go before the assigned judge with more information provided. I can tell you I reviewed the PC affidavit from the previous arrest. She was on pretrial, and it's essentially identical. It just involves a different doctor's office. There are clearly issues going on right now. I don't know how Ms. Torino is getting these scripts from these doctor's offices, but I don't know that the court can have confidence that if she's allowed out of custody right now, she won't be doing the same thing that she now has 2 open felonies for.
Do you have anything else that you want to add?
Judge, she's right now, her and her husband recently separated, so she's the primary custodian of her kids. Right now, the kids are with her ex-husband, but based on that, that is why I'm asking the court to consider releasing her on level 2 supervision.
Okay, well, I'm concerned with some issues that may be going on here. Based on the information I'm receiving from pretrial, she was originally placed on pretrial supervision on December 31st of 2019. We have this similar or same issue occurring now less than a month later. So I think that this is going to have to be addressed by her division judge. So for the time being, she's going to have no bond holds on the case that was on pretrial. That applies to all 4 counts in that case.
Yes, Judge.
I'll hear the recommendations as to the case that's on the docket today for first appearance.
Your Honor, considering she'll have to go in front of her judge, I'm fine with the standard bonds on these 2 new charges.
Nothing to add from the defense, Judge.
All right, in light of that, the standard bonds will remain in place on the new case. Thank you. Kalia Walks.
She's approaching, Judge.
Thank you. Good morning, Ms. Walks.
Morning.
Ms. Walks, you were before the court this morning on 1 count of child abuse without great bodily harm. I find probable cause, and I'll hear from the parties.
Your Honor, I'm going to be requesting a $5,000 bond and no victim contact for several reasons. She has no history, but I would note this is based on the level of violence committed against the alleged victim, not only by Ms. Walks, but her husband as well. As his primary caregiver, it was her responsibility to protect her child from that as well. As not striking, as mentioned in this, I'm concerned that it would appear based on the victim's statements that through fear, the child was instructed and taught not to tell anybody about the abuse he was suffering at home. It would also appear that Ms. Walks, when she did give a statement, was less than truthful about the abuse that was being committed against her child at home. I think the report speaks for itself.
Judge, in speaking with Ms. Walks, actually, she's right now has a court date in front of Judge Bovian, set to appear before at 10 a.m. regarding this incident. My understanding is she has been going to court. Last time she went to court was November 7th. My understanding, she is currently in parenting classes. She's fulfilling her case plan. She has individual counseling, co-parenting classes. My understanding is one of the reasons why she was going to go to court today was to address the issue of visitation. Right now, there are supervised visitations in place, which is Tuesdays and Thursdays for 1 hour a day. My understanding is the child was removed. Right now, the child is with his biological father. My understanding is that right now, as you heard from the state, she has no prior contact. She has a clean record. First time being arrested, she's a registered voter. She works. She lives here locally, Judge. This case is being addressed. She's working out through all these different courses. I believe she'll be in a better position. But Judge, at this time, I'm going to be requesting a $2,000 bond And I'm gonna be objecting as far as the, no contact, with the child, Judge.
Your Honor, I would just note, this is now a criminal matter, and because there are allegations that Ms. Walks in the past has threatened the victim, who is also a witness in this case, to lie about what happened, my concern is if contact is allowed, she could impact the child's ability or willingness to testify at a future date.
Based on the situation and the arguments that have been made this morning, I'm going to set bond at $2,000, but in an abundance of caution, there will be a no victim contact order until further order of the court. If her division judge decides otherwise, then that will be for the division judge to decide. James Clee.
He's approaching, Judge.
Thank you. Good morning, Mr. Clee. Mr. Clee, you're before the court this morning on an out-of-state felony hold. This is, let me just confirm. This is out of the state of Michigan. It's for a parole violation and has a no bond hold on it. I find probable cause. And Mr. Clee, since this is an out-of-state hold, that means that you'll have to go before the extradition judge. So you should be set in front of her shortly to have a hearing to address how this matter is going to be handled. Thank you. Napoleon Culver.
Mr. Culver, come on up, please.
Good morning, Mr. Culver.
Good morning.
Mr. Culver, you are before the court this morning on one count of domestic battery by strangulation. I find probable cause. I'll hear from the parties.
Sorry.
Pretrial is standing up.
No, I didn't know.
Mr. Culver is being supervised by pretrial services.
You have a less habitual offender? I see.
Judge, we can't hear.
Your Honor, based on the court's finding out probable cause, we're gonna act as pretrial status as we move forward on that case. 19-3077 CF10, driving while licensed.
It's on pretrial.
I'll have to check the date. What's that one? I didn't write it.
Based on the request, I'm going to grant pretrial's request to revoke his pretrial supervision in that case.
Judge,
And just so you
if
know,
I
he
may
was
be
on an
heard before the
electronic
court
monitor.
actually makes a ruling.
One moment, Mr. Mayor, what was that?
He was actually on an electronic monitor.
He was on an electronic monitor? All right, Mr. Romero. He was on a level 2 GPS, okay. Mr. Romero, what do you want to tell me?
Judge, my understanding is the new offense that was picked up is not similar to the prior case that he's been on supervision. And based on that reason, Judge, I'm asking the court not to take any action on the case that he was on supervision for. I would be asking for the case that's currently before the court to set a $3,500 bond on Mr. Culver's behalf. Now, my understanding, Judge, he's been here his whole life. He's works at Pace Setters. He lives apart from the victim. He lives in Hallandale in a trailer where he's been staying at for the past 3 years. My understanding, Judge, is, and I didn't read the PC affidavit, but my understanding, Judge, is when the police, I believe, responded to the scene, I believe the alleged victim was hesitant about pursuing criminal charges. So, Judge, under the circumstances, since it's a different offense, I'm asking the court, once again, not to take any action on the case that he's on pretrial and impose a $3,500 bond on this case.
State.
Yes, thank you, Your Honor. Well, Your Honor, I can tell you first far as revoking. He's already had his bond in the DWS case revoked once before by Judge Coleman. That was when he picked up a new unlawful use of false name ID and no valid DL. This obviously is a much more serious violation. And from what I can tell, Judge Coleman ordered him to be held no bond. Then he was released to pretrial, and he violated pretrial. He violated pretrial. He was on a GPS monitor by failing to remain confined to his residence at all times except for pre-approved times. So Judge Coleman signed a warrant to hold him no bond for violating pretrial. He then was released again on a GPS monitor and is now before the court for allegedly committing a felony-level act of violence against his victim, a woman that he has been arrested previously for committing violence against. Last year, he was arrested for aggravated assault with a deadly weapon and domestic violence battery by strangulation against the same alleged victim. That was dropped. He was convicted of a battery against her in 2018. He's also been arrested for violence against other women. In 2017, he was arrested for violating a domestic violence injunction against a different woman. That was dropped. 2016, he was convicted of felony battery causing great bodily harm against a different woman. 2015, he was convicted of assault against a woman. In 2013, he was convicted of violation of a domestic violence injunction. He was arrested for battery in 2012, and that was dropped. Your Honor, he also has priors and arrest for violation of an injunction that was dropped. Another conviction of battery in violation of a domestic violence injunction, conviction for robbery with a firearm or deadly weapon and resisting with violence that he was sentenced to prison on, multiple drug priors. I would also direct the court's attention to Mr. Culver's booking sheet so you can see the amount of aliases he has used in the past. Jarvis Wilson, Dennis Wilson, Andrew West, David Jennings, just to name a few. I believe he's risked to not show up in court considering he's already violated pretrial by essentially walking away from just leaving his residence. He uses aliases. He's also a threat to the community based on his history of violence and the allegations in this case.
Judge, the only additional piece of information I realized Mr. Lender said the first time he violated pretrial in this case was by picking up an offense. My understanding, speaking to Mr. Culver right now, that offense was actually dropped. So I just wanted the court to take that into account.
I imagine that's why he was probably released on a GPS monitor, that he violated that as well.
State, what's your recommendation as to monetary bond?
On the DWS case or this case? On the DWS, Your Honor, it'd be no bond. He's already been held no bond once for violating his, well, twice for violating his conditions. On the strangulation, considering the history, specifically with this alleged victim and in general, $10,000. If I would ask if the court is inclined to set a bond on both cases, that he be placed back on a GPS monitor. He shouldn't be able to avoid a GPS monitor by committing a new law offense.
Right. In case number 19003077 CF10A, I'm going to grant pretrial's request and sign the revocation order. You will have a no bond hold placed in that case. The new case that's before the court today, bond will be set at $10,000. There will also be an order of no victim contact. Mr. Culver, no victim contact means...
Mr. Culver, come on. Yeah, she's going to explain no victim contact. Come on.
All right, that's all right, Mr. Romero. He can take it up with his division judge. He's not going anywhere anytime soon. Thank you. Carone Bailey.
Mr. Bailey, come on up, please. He's here. Judge President May.
Good morning, Mr. Bailey.
Good morning.
Mr. Bailey, you are before the court this morning on count 1, aggravated assault with a deadly weapon, domestic violence. Count 2, battery causing bodily harm, dating violence. Count 3, aggravated battery with a deadly weapon. Count 4, carjacking with a firearm or weapon. I find probable cause, and I will hear from the parties.
Your Honor, in the first case, the first two counts, I'm going to be requesting a $25,000 bond on count one, $5,000 bond on count two. On count three, I'm going to be requesting a $75,000 bond, considering he discharged the allegation of the warrant is he discharged the firearm and the victim was struck multiple times. On count four, the carjacking with firearm or weapon, that's a punishable by life offense. I'm going to be requesting a no bond hold upon a finding of proof evident or presumption great for first appearance purposes, Your Honor. Should the court find proof evident or presumption great, I would be requesting that the court not exercise discretion and that he be held no bond. I believe he poses a significant danger to the community, taking these two cases, considering both of them together. Also noting in 2018, he was convicted of possession of firearm or ammunition by convicted felon. Two separate cases, sentenced to just under 19 months in state prison, and he was just released from state prison November 5th of 2019.
Yes, Judge, would object to the court making a finding of proof evident presumption great at this stage of the proceedings. It is the highest burden of proof that we have in the criminal justice system. The state has not called any witnesses. They've not introduced any evidence. And based on this report written by an officer who did not witness the events himself, we would ask that this court not make a finding of proof evident presumption great. If for our objection the court does make such a finding, then we would encourage the court to exercise its discretion and set bond for Mr. Bailey.
Thank you. All right, I have reviewed the probable cause affidavit as it relates to count four. These are obviously some very, very serious allegations based on the information that has been provided in the probable cause affidavit without going into detail. At this time, the court will make a preliminary finding of proof evident presumption great. I will order that Mr. Bailey be held no bond on count four. That is without prejudice for him to have a hearing before his division judge to further address that matter. I will hear the defense's recommendations as to count 1, 2, and 3 if they wish to be heard.
Judge, considering as a no bond hold, he's going to have to go in front of his division judge for relief. Nothing to add at this time, Judge.
All right. In light of that, on count 1, bond will be set at $25,000. On count 2, bond will be set at $5,000. On count 3, bond will be set at $75,000. Additionally, there will be a no victim contact as it relates to both of the alleged victims in this case. Mr. Bailey, so that you understand, no victim contact means no phone calls, no text messages, no third-party contact, no social media. And once again, that relates to both of the alleged victims in this case. Do you understand that, sir?
Amen.
Thank you. Kevin Powell.
Approaching, Judge.
Thank you.
He's here, President.
Thank you. Good morning, Mr. Powell.
More.
Mr. Powell, you're before the court this morning on one count for grand theft greater than $750, less than $5,000. Count 2 is a felony probation violation that has a no bond hold on it. I find probable cause. I see that Mr. Powell has a VOP hearing before his division judge tomorrow morning. In light of that, do the parties wish to be heard on count 1?
Nothing from the state.
No, Judge.
All right. Then the standard bond will remain in place on count 1. Herbesia Deschamps. Good morning, Mr. Deschamps. You're before the court this morning on count 1, DUI, alcohol or drugs, first offense. Counts 2 and 3 are DUI with damage to property or person of another. Count 4, DUI with the blood alcohol level greater than 0.15. Count 5 is for careless driving, that is not for magistrate. Count 6 is for driver failing to present current proof of insurance. I find probable cause, and I'll hear from the parties.
State Judge.
Nothing to add, Judge.
All right, in light of that, the standard bonds will remain in place. Thank you. Morris Phillips. Thank you.
No prior.
Thank you. Good morning, Mr. Phillips.
Good morning.
Mr. Phillips, you are before the court this morning on 2 ad charges. Count 2 is for possession of cocaine. Count 3 is for threat with death or serious bodily harm to law enforcement. I find probable cause.
Your Honor,
Yes.
Mr. Phillips should be ROR'd on both of these counts.
Okay.
He was originally released on a defense motion for release on this case.
Okay.
That's why it says ROR on count 3.
Yes.
What happened was state filed a change of charge. Originally, the cocaine was a methamphetamine. So when we filed the change of charge KPS was created. But the ROR still is attached to the case, even if we file a different charge.
All right. So, Mr. Phillips, you're going to be ROR'd on both of these counts. That means that you will be released, assuming that nothing else is holding you. But you need to understand that just because you're being released today doesn't necessarily mean that's the end of the case. So it will be your responsibility to keep in contact with your attorneys in the clerk's office to monitor any future court dates that you need to be present for. Do you
I'll check
understand
to see
that?
if an arraignment date's been given yet.
Okay. Tell me.
Well, Mr. Phillips, I guess that answers your question that we were talking about earlier.
Yes. And the court date that I have for
Read.
March 9th, that's for this case.
That's what we're checking right now.
Mr. Phillips, you were arraigned yesterday by Judge Coleman?
Yes, sir.
Yes, then the court date you got, that's going to be your next court date on this case.
Okay.
Okay.
All right. Thank you. Good luck, Mr. Phillips.
All right, good luck.
Could Jeffrey Nathan?
Please approach the judge here, Maine.
Thank you. Good morning, Mr. Nathan.
Good morning.
Mr. Nathan, you're before the court this morning on an ad charge. Count 3 is for murder, dangerous or depraved without premeditation. This is a charge for second-degree murder. I find probable cause, and I will hear from the parties.
Your Honor, just a brief history. Mr. Nathan came before, I think he appeared before Judge, trying to remember. Was it Judge Bailey? Thank you. He appeared before Judge Bailey over the weekend when at first he was charged with attempted second-degree murder, a bondable offense. A $30,000 bond was set. Now that as it is mentioned in the affidavit, unfortunately the alleged victim succumbed to his injuries and is now deceased. The detective prepared a new warrant for murder in the second degree, which is a punishable by life offense. Based on that, Your Honor, in the affidavit that has been provided, the state is going to be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes only.
First-degree murder?
Second degree.
Second-degree murder.
Punishable by life.
All right. Then, Judge, we would object to the court making a finding of proof evident presumption great at this time. My reading of the probable cause affidavit seems to indicate that this was a fight between two individuals in which the victim was unfortunately injured, I guess has now passed away. But there's no indication in the probable cause affidavit as to who started the fight or whether Mr. Nathan was acting in self-defense. The only witness to the event is the victim's friend, who is probably not to be considered a completely unbiased witness. And in light of the fact that proof evident presumption great is the highest burden of proof that we have in the criminal justice system, I would ask the court, since there are so many unanswered questions here, not to make a finding of proof evident presumption great and to set a bond for Mr. Nathan.
Thank you. All right, I appreciate the arguments that have been made. I have reviewed the probable cause affidavit, and at this time, the court is going to make a preliminary finding of proof evident presumption great and have Mr. Nathan held no bond on this charge. That is without prejudice for him to have a hearing before his division judge to further address that matter. This is for first appearance purposes only. We'll do 2 more cases and then we're going to take a brief recess. Next will be Johnny Caesar.
He's in Conte, Judge.
Okay, thank you. Does anyone at Conti have Johnny Caesar? Thank you, Deputy. Good morning, Mr. Caesar.
Good morning, Your Honor.
Mr. Caesar, you're before the court this morning on 2 ad charges. Count 5 is for burglary of an unoccupied conveyance unarmed. Count 6 is for second-degree petty theft, first offense. I find probable cause, and I will hear from the parties.
Your Honor, Mr. Caesar is already being held no bond on a separate felony for violating pretrial. I'd be requesting a $2,000 bond on count 5.
In light of the no bond holds, Judge, he's going to have to go in front of his division judge anyway, so I guess a $2,000 bond is something that could be addressed at the same time as the no bond holds.
Okay, I would agree with that. All right, then bond on count 5 will be set at $2,000. Thank you, Mr. Caesar. Matthew Pullins. Good morning, Mr. Pullins.
Mr. Collins is here present, Judge May.
Thank you. Mr. Pullins, you're before the court this morning on count 1, possession of cocaine. Count 2, possession of methamphetamine. Count 3, possession or use of drug paraphernalia. I find probable cause, and I'll hear from the parties.
Judge, we're going to be requesting a phone order.
I will sign that order. Anything further from the state?
Nothing from the state, Judge.
All right. In light of that, I will leave the standard bonds in place, and I'll sign the phone order as requested by the defense. Okay, at this time, we're going to take a brief recess. We'll come back in just a few minutes to finish up the docket. All right, hi everyone, we're back on the record. We'll continue. Next will be Isaiah Johnson.
He's in Maine, Your Honor.
Thank you.
Judge, she's here present.
Okay. Do you need more time?
No, I'm ready to proceed, Judge.
Okay. All right, good morning, Mr. Johnson. You are before the court this morning on one count of robbery by sudden snatching without a firearm or weapon. I find probable cause, and I'll hear from the parties.
Your Honor, I'm going to be requesting a $7,500 bond, no victim contact, on this robbery, noting that Mr. Johnson has an open aggravated battery causing great bodily harm out of Dade County.
Judge, Mr. Johnson's not going to be able to afford what the state has recommended. Now, he's been here his whole life. He's 25 years old. Right now, he's the main provider of his household, helping his mom. He's a father. He has a child. The child doesn't reside with him. He's not ordered to pay child support, but he has an informal, agreement with the child's mom, which he financially supports the child. He pays about $800 a month in order to provide for his child. In order to do that, he has two jobs, Judge. He works as a security guard, where he got the job approximately 4 months ago, where he's making only $12 an hour. He has a second job, which is at a gas station, and he got that job approximately 3 months ago, in which he's making $10 an hour. He's working as many hours as he can just to provide for his son, Judge. But his mom is the only person that's going to be able to help post his monetary bond. Using the services of bondsman, he believes that most she can afford is about $1,000 bond. So that's what we're requesting on this offense, Judge.
Just to give the court an idea, he's out on a $10,000 bond out of Dade.
Does he have any other priors besides the one pending case?
Showing a resisting without violence from 2012. I'm also showing non-expiring injunction. Well, no, I'll leave it at that. That's his only other prior, Judge. Yes.
Set at $5,000.
Judge, how much?
$5,000. There's also going to be an order of no victim contact. So Mr. Johnson, so that you understand, no victim contact, besides not being in the same place at the same time, means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Thank you. Freddie Ross.
Here, Judge, in Maine.
Thank you. Good morning, Mr. Ross. You are before the court this morning on one count of second-degree petty theft, third or subsequent offense. I find probable cause. I'll hear from the parties.
Judge, I did talk to Mr. Ross regarding the standard bond, $750, but unfortunately, Mr. Ross is not going to be able to afford that. We're going to be requesting that Mr. Ross be released under supervision of pretrial release. He's been here his whole life. He's 28 years old. He lives locally here in Fort Lauderdale, where he rents an apartment with both a sister and his roommate, where his share of the rent is about $300. Unfortunately, he was terminated. He's currently looking for employment. Judge, my understanding is he has prior contact, but it's been several years dated. Considering this is a non-violent offense, I'm asking for Mr. Ross to be released under supervision.
Okay. State.
Sorry, was the request for pretrial?
Correct.
Does he have a residence?
Yes, he lives locally here in Fort Lauderdale.
I have no objection.
With his brother-in-law.
Okay.
I have no objection to pretrial, Your Honor.
All right, then, in light of that, I will ROR Mr. Ross to pretrial. He'll be placed on standard pretrial. Mr. Ross, a couple of important things for you to note there. Your attorney is giving you some information. Once you are released, you'll have 24 hours to report to pretrial supervision. If you fail to report as instructed, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
All right, thank you very much. Joshua Johnson. Hi, guys. Mr. Johnson. Mr. Johnson, you are before the court this morning on count 1, second-degree petty theft, third or subsequent offense. Count 2 is a felony probation violation that has a no bond hold. I find probable cause. I see that Mr. Johnson has a hearing before his division judge tomorrow morning on the violation of probation. In light of that, do the parties have do they want to be heard on count 1?
No, thank you.
All right. The standard bond will remain in place on count 1. Thank you. Benson?
He's approaching, Judge.
Thank you. Good morning, Mr. Denson.
Good morning, ma'am.
Mr. Denson, you are before the court this morning on 1 count of grand theft, greater than $750, less than $5,000. I find probable cause, and I'll hear from the parties.
Judge, we're going to be requesting Mr. Denson be released straight ROR. My understanding, Judge, he's been here his whole entire life. He's 49 years old. Right now, he has a number of health issues. He's had 3 strokes. He's currently taking daily medications. He goes regularly to his doctor's appointment. He lives locally here in Miami Gardens. He has family here. Judge, he has very strong ties to the community. Judge, he did advise me as priors, but it's been several years. This is a non-violent offense. Mr. Denson did advise me he's going to be coming back to court. He's going to make sure not to miss any court. But Judge, right now, considering everything which I stated, that's why I'm asking for the court to consider releasing Mr. Denson ROR on this offense.
State.
I would be opposed to an outright ROR. He has been to state prison. I'm showing as far as Broward goes, 2007 aggravated assault and battery under the name Terrence Daniel, possession of cocaine, resisting without violence. 96 delivery of cocaine, possession of cocaine with intent. He's been to state prison out of Dade County in the 90s for strong arm robbery, robbery with a firearm or deadly weapon, aggravated assault with a deadly weapon, sale, delivery of cocaine, possession of firearm by convicted felon. On the robbery, firearm, and strong arm robbery, he was sentenced to 9 years in state prison. Just noting, he's also used other aliases, Kevin Gray, Kevin Jones. So I'd be opposed to an ROR.
What was the most recent crime?
No. resisting without violence, 2010 in date. He's had arrests in 2014 in date, but those were dropped.
I'm not going to give Mr. Denson an outright ROR, but I will have him placed on pretrial supervision.
Yes, Judge.
All right, then additionally, there will be a no return order. So, Mr. Denson, there's a couple of important things for you to know.
Yes,
Number
ma'am.
one, you're gonna get some information from your attorney right there regarding pretrial supervision. You must report to pretrial within 24 hours. If you fail to report to them as instructed, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am, I do.
Okay, additionally, there's going to be a no return order in place for the time being. That means that you are not to return to the Walmart at 1800 South University Drive. Do you understand that?
Yes, ma'am, I do.
All right, thank you very much. Adrian Bermudez. Good morning, Mr. Bermudez. Mr. Bermudez, you're before the court this morning on count 1, burglary of an unoccupied conveyance unarmed. Counts 2 and 3 are for felony probation violations, each of which has a no bond hold. Count 4 is for burglary of an unoccupied conveyance unarmed. I find probable cause. I see Mr. Bermudez does have a hearing before his division judge on the VOP issue tomorrow morning, so I will hear from the parties with regards to count 1 and 4.
Listing
Judge, considering as no bond holds on the VOP, and these are count 1 and 4 third-degree felonies, we're going to be requesting $1,000 bond on each.
requesting $2,500 on each, Your Honor, considering one of the cases on probation for was a robbery.
Bond will be set at $2,000 on count 1 and $2,000 on count 4. Rodney Atkinson.
Come on up, Mr. Atkinson.
Good morning, Mr. Atkinson.
Good morning.
You're before the court this morning on one count of grand theft auto. I find probable cause. I'll hear from the parties.
Judge, speaking of Mr. Atkinson, we're going to be requesting Mr. Atkinson be released on pretrial release. Now, he's been here his whole entire life. He's 25 years old. He just started. He has a good job. It's called Overnight Dollar Tree. He hasn't even gotten his first paycheck yet, Judge.
No objection to pretrial.
Thank you.
Okay, well, that makes that easy. All right, so Mr. Atkinson, you're going to be released to pretrial supervision. You're going to get some information from your attorney there. You will have to report to pretrial within 24 hours. If you fail to report to them as instructed, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
All right, thank you very much. Michael Crum.
He's here for you, Judge, and me.
Good morning, Mr. Crum. Mr. Crum, you're before the court this morning on count 1, criminal mischief, $200 or less, subsequent offense. Count 2 is an out-of-county felony hold. That is not for magistrate. That's from Palm Beach County. I find probable cause, and I'll hear from the parties as to count 1.
Judge, considering the out-of-county hold, nothing to add at this time.
State anything?
No, Judge.
All right, the standard bond will remain in place on count 1. Thank you. Duncan Mitchell.
He's approaching, Judge.
Thank you. Good morning, Mr. Mitchell.
Good morning to you, too.
You are before the court this morning on one count of grand theft, greater than $750, less than $5,000. I find probable cause, and I'll hear from the parties.
Judge, nothing to add from the defense.
State.
$1,000 bond is fine, Judge.
Right. The standard bond will remain in place. I'm also going to impose a no return order. Mr. Mitchell, so that you understand, no return means that you are not to return to the Lowe's store that this allegedly occurred at. Do you understand that, sir?
Yes.
Thank you very much.
Okay, I'll call your brother in about 15 minutes.
Keanu Bajzath.
Mr. Bashstaff? He's approaching, Judge.
Thank you. Good morning, Mr. Bajzath.
Good morning.
You are before the court this morning on one count of grand theft auto. I find probable cause. I'll hear from the parties.
Judge, we're going to be requesting pretrial before I proceed. I'll see if the state has an objection.
That's fine.
All right. Then, Mr. Bajzath, you're going to be released to pretrial supervision. You're going to be getting some information from your attorney there. You will have to report to pretrial within 24 hours. If you fail to do that, a warrant will be issued for your arrest. Do you understand that, sir?
Yeah.
All right. Thank you. Kenrick Walks.
Come on up, sir.
Good morning, Mr. Walks.
Good morning.
You are before the court this morning on one count of child abuse without great bodily harm. I find probable cause. I'll hear from the parties.
You set the same bond that you set for his co-arrestee with the same charge, a $2,000 bond in order of no victim contact.
Judge, under the circumstance that I did advise Mr. Walks that, and no objection at this time.
All right. In light of that, bond will be set at $2,000. There will also be an order of no victim contact. So, Mr. Walks, so that you understand, no victim contact, aside from not being in the same place at the same time, means no phone calls, text messages, third-party contact, or social media. Do you understand that?
Could you repeat the last part again?
No victim contact means no phone calls, no text messages, no third-party contact, no social media. You understand that?
Yes.
Okay, thank you. Michael Greenstein?
Yes.
Good morning, sir.
Good morning, ma'am.
Mr. Greenstein, you're before the court this morning on count 1, possession of methamphetamine, count 2, possession of GHB, count 3, possession or use of drug paraphernalia, count 4, driving while license suspended, first offense, count 5, driving with a license from other state when Florida license is suspended, and count 6 is for unlawful speed. That is not for magistrate. I'll hear from the parties.
Judge, nothing to add from the defense.
Nothing
Anything
from the
from
state.
All right. In light of that, for the record, I find probable cause, and the standard bonds will remain in place at this time. Thank you. Alberto Delgado.
He's approaching, Judge.
Thank you. Good morning, Mr. Delgado. Mr. Delgado, you are before the court this morning on count 1, possession with intent to sell, manufacture, or deliver cannabis. Count 2, possession of cannabis, 20 grams or less. Count 3, possession of a two-way communication device to facilitate a felony. Count 4 is for having an expired tag. That charge is not for magistrate. I find probable cause, and I'll hear from the parties.
Judge, nothing to add.
Nothing from the state.
All right. In light of that, the standard bonds will remain in place. Thank you. Jeremiah Garvin.
Medical.
He's a medical reset again. All right. Michael Cooper.
Miracle?
Roderick Lockhart.
He is in North Broward, Judge.
Thank you.
How you doing? North Broward?
Thank you. Good morning, Mr. Lockhart.
How you doing, Your Honor?
I'm good so far. Mr. Lockhart, you are before the court this morning on count 1, second-degree petty theft, third or subsequent offense. Count 2 is a misdemeanor capias. That is a municipal ordinance violation for trespassing.
Can I resolve that?
We're gonna find out 1 minute. I find probable cause, and let me hear from the parties on count 1.
Judge, Mr. Lockhart indicated to me a desire to resolve count 2 and leave count 1 where it is.
Can I get pretrial on count 1?
Well, yeah, we can ask the court if you can do pretrial,
Thank
sure.
you, sir.
Sure, all
Thank
right.
you, sir.
All right, State?
From what I can tell, Mr. Lockhart is already out on a felony theft right now.
On,
State would oppose pretrial.
he's out on pretrial or he's out on bond?
He's out on bond. But he's also got, that's a 2019 case. 2018 grand theft, 364 days in county jail. 2018 felony theft, same sentence. 2017 felony theft. 2016 theft. 2014 felony theft, VOP. 2013 felony theft, VOP. 2012 felony theft, 2011 felony theft, 2011 felony theft, another one in 2011, another petty theft in 2011, felony theft 2010, theft 2010. I see 1, 2, 3, 4, 5, 6, 7,
Get time for all that.
7, 8, 9. 9 more thefts of some nature, either felony or misdemeanor.
Okay. All right, so Mr. Lockhart, as on count 1, I'm gonna leave the bond in place. On count 2, count 2 is the municipal ordinance case. Based on the information that's been given to me, the offer would be an adjudication time served if you want to resolve that particular count.
Yes, I do, ma'am.
All right, so will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. Lockhart, do you understand everything we've discussed so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
On count 1, can I get that bond lowered a little bit so I can, after I go to put mine out?
Not at this time, Mr. Lockhart. I'm going to leave that one at $750, okay?
All right, then.
All right.
Thank you, ma'am.
Okay, is there anything else that you need to discuss with your attorney at this time?
No, ma'am.
Okay, all right, hang tight. I've got a couple more questions for you. Hold on.
All right.
I got a couple more questions for you, okay?
Yes, ma'am.
Do you, this is just for the municipal ordinance case now, okay? Do
Yes,
you
ma'am.
understand that you have the right to trial, but you are waiving that right by taking a plea?
I would like to go to trial because I was assaulted on that case.
On the municipal ordinance case?
That was an assault case. I didn't really trespass. I got assaulted by a security officer in the store.
Okay, all
I
right.
would like to, I'm going to resolve it today because I need that wiped away.
So you
I
do,
could.
you want to resolve it or you want to go to trial?
I'm going to resolve that.
Okay, so you understand that you have the right to a trial, but you're waiving it by taking a plea?
Yes, ma'am.
Okay, are you sure? You sure that's what you want to do now?
If I don't waive it, then the warrant's still there.
If you don't want to resolve it today, then we'll talk about bond on that case, all right?
I'm going to resolve it.
All right, I'm going to ask you one more time. Are you sure that's what you want to do?
Yeah, I'm going to resolve it.
Okay. All right, Mr. Lockhart, have you ever been treated for mental or emotional illness?
Yes, ma'am.
Okay. Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
Okay. Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
Okay. And what plea do you wish to enter? Guilty or no contest?
No contest.
All right. I accept your plea and find that it is freely and voluntarily given. So, Mr. Lockhart, your sentence as to the second count only, which is a municipal ordinance violation, the sentence will be an adjudication time served.
All right, thank you.
Okay, you're welcome. Ronald Shines.
North Broward, Judge.
Thank you. Good morning, Mr. Shines. Mr. Shines, you're before the court this morning on one count of burglary of an unoccupied conveyance, unarmed. I find probable cause, and I'll hear from the parties.
Your Honor, I'm going to be requesting a $7,500 bond on count one. Mr. Shines is out on pretrial right now. He was just arrested January 7th for 3 counts of burglary conveyance and was released January 9th. I've been advised that a warrant has been taken to his assigned judge. I don't know what has happened with that yet, though.
So it's going to the assigned judge. All right. Mr. Reading?
Well, I was going to ask for pretrial release. I know that Mr. Shines has been a resident here for 7 years. He had a job as a veterinary technician, which I believe he no longer has due to his arrest. He was in the process of moving when he was arrested. And he's given me the name and number of his mother, who I can call for him, but I have a feeling that as far as monetary bond is concerned, Mr. Shines is not going to be able to come up with a great deal of money.
All right. Based on the information that's been provided by pretrial, I'm going to set the bond on this case at $5,000. And we'll see what his division judge decides to do with the case that's on pretrial right now. All right, thank you. Dylan Erb.
I've advised Mr. Erb is in court.
Okay. All right. Then that brings us to the end of our morning docket for first appearances. We will break and I'll see everybody back here at 1 o'clock. Thank you.